Answer.
Get the latest weather, traffic, and news updates online at 560theanswer.com. Now, from the Signature Bank Studios, this is Chicago's Morning Answer with Dan Proft on AM 560. The Answer.
Top of the morning, Dan Proft here. Oral arguments on President Trump's Birthright Citizenship executive order, as in ending it, consistent with his interpretation of what the 14th Amendment provides. Will he show up for oral arguments today? He indicated he might. I know other members of the cabinet are going to show. This is what President Trump had to say from the Oval Office yesterday about his EO and the case.
And if you take a look at when it was filed, all of this legislation, all of this, everything having to do with birthright citizenship, it was at the end of the Civil War. The reason was it had to do with the babies of slaves and the protection of the babies of slaves. It didn't have to do with the protection of multi-millionaires and billionaires wanting to have their children get an American citizenship. It is the craziest thing I've ever seen. It's been so badly handled by legal people over the years.
Well, hopefully the legal people, nice term, the legal people in robes will handle it better this go around. You know, sometimes obnoxious Supreme Court decisions last for a long time. I mean, Plessy v. Ferguson was decided in 1896. It took 58 years to overturn the absurd idea of separate but equal and the segregation of the races. It took Brown v. Board of Education almost 6 decades later. And we have a similar situation here, it seems to me, at least in part, which will inform our discussion with Professor Barnett, Randy Barnett, who will join us momentarily. And this is the case we've discussed before when this issue first arose, when he first issued this executive order, when Trump was reelected, and he made this central to his vision for legal immigration in America. And it's the Wong Kim Ark case, San Francisco, Chinese family living in San Francisco, that was decided in 1898, in which the court essentially affirmed birthright citizenship. That's the way it's been interpreted. When Wong Kim Ark, born in this country to Chinese parents who were legally in San Francisco, even though they were not citizens, they were allowed to come and operate a business. In those days, you were allowed to legally come, even if you were not a citizen, per the Chinese Exclusion Act, but you were allowed to legally be here. He leaves. They don't let him back in. The Supreme Court rules, since he was born in the United States, he should be let back in. He is a citizen, and here we are 128 years later, revisiting that decision. For more on this, pleased to be joined by the aforesaid Randy Barnett, professor of law at Georgetown University, author of the book we just had him on last week to discuss, Felony Review, Tales of True Crime and Corruption in Chicago, which I know last time you were here, that our discussion of Tales of True Crime and Corruption in Chicago got a lot of interest, and so I hope there are a lot of people who ordered your book. Randy Barnett, thanks for joining us again. Appreciate it.
Well, thanks for having me on, Dan. Not only did people buy the book, but I got a call from a circuit court judge, phone call at my office at Georgetown, thanking me for writing the book. And I was really honored because this was one of the guys who, when he was a Cook County State's attorney, he was one of the guys who was senior to me, who I really looked up to. And I told him I was really kind of uncomfortable because there were all these guys that did such a better, they were so much more experienced and skillful than I was. And I'm the way I read in the book. So I felt a little uncomfortable. And his response was, yeah, but somebody's got to write the book. Somebody's got to be able to write the book, and you're able to do it. So you're kind of doing this for all of us. And that was just so wonderful to hear. And it was made possible by my being on your show.
Yeah, great perspective. Yeah, very good. Well, let's talk about birthright citizenship. His use of legal terms of art notwithstanding, does Trump have it basically right?
I have a piece in the Wall Street Journal today. If anybody reads the Wall Street Journal, an op-ed saying he does have it right. A year ago, I had an op-ed in the New York Times and saying that he might have a stronger case than people give him credit for. But up until that point, the originalism scholarship had not been done systematically, and most importantly, that scholarship that has been done had not been thoroughly critiqued. And in the last year, there has been an explosion of originalist scholarship and argumentation on both sides of this question, and each side has been vetting the other side. And now we're in a position to reach a conclusion. And most importantly, the justices today are in a position to reach a conclusion on the original meaning of the 14th Amendment. And I believe now that it does not provide for what's called birthright citizenship for people who are unlawfully or temporarily present in the United States. So I do think the executive order is constitutional. President Trump has it right, but the conventional wisdom says this case is going to go the other way, and we'll have to find out what the temperature of the justices are this morning.
Well, just to revisit the word or phrase that is central to the discussion, the argument, jurisdiction or subject to the jurisdiction thereof. That's the key. That's the key. The word jurisdiction is what needs definition. And so give us your definition.
Yeah, this is what's just really lost in the conventional wisdom here. And by the way, I don't believe this is like Plessy versus Ferguson situation. We do not have a Supreme Court case that has held that people who are unlawfully or temporarily present here are entitled to, their children are entitled to citizenship.
No, but yeah, but I mean that's what's been used. That case.
It has been used, but Wong Kim Ark didn't say that. The question presented in that case, as I point out in my Wall Street Journal piece this morning, was whether someone who was a permanent resident, not a citizen, but a permanent resident of the United States, whether their children were citizens of the United States. And they said they were. The government is not contesting that case. They're not contesting that result, and the executive order doesn't go against that result either. Green card holders, for example, their children would be American citizens under President Trump's executive order. Now, you're absolutely right that the conventional wisdom is focusing entirely on the first of two requirements specified by the 14th Amendment. The first is that a person must be born in the United States. But that's only the first of two requirements. The second requirement is that they must be subject to the jurisdiction of the United States, subject to the jurisdiction thereof. And it was well recognized, and people on both sides of this debate recognized there were three categories of persons who were not considered to be citizens of the United States, not considered to be subject to the jurisdiction thereof at the time the 14th Amendment was enacted. And those categories were children of diplomats, children of invading armies, and children of those Native Americans who were affiliated with a tribe, or we would call them tribal Indians. Their children, the status of the children were dictated by the status of the parents, and the status of the parents they were not subject to the jurisdiction thereof. The whole debate is about whether the concept that explains or justifies these three well-recognized exceptions, whether that concept of subject to the jurisdiction thereof also would exclude those who are unlawfully present or temporarily present. And so my position is that that concept does exclude that. And the other side says, no, pretty much these three categories are the only categories that are covered by that concept. That's what the entire debate is about. So everybody listening to this should realize that as complicated as this is going to sound, it's actually about a very narrow question. Is the concept subject to the jurisdiction thereof broad enough to exclude, in addition to children of ambassadors, children of invading armies, and children of Native Americans who are affiliated with the tribe, who are, by the way, now citizens by statute, whether it would also include unlawfully and temporarily present persons.
Well, right, yeah. So I mean, it boils down even simpler than that. If temporary. Subject to the jurisdiction of temporarily, you're here legally, you're on a student visa, you're on a tourist visa, you're on an H-1B, that's temporary. Subject to the jurisdiction thereof, for the citizenship purpose, it would logically implicate permanently. And so anything less than permanence should not provide for citizenship. That's basically the argument.
Yeah, and not only that, but as the government pointed out in their brief, the end of the provision we're talking about also says that persons born in the United States subject to the jurisdiction thereof are citizens of the United States and of the states in which they reside, which specifically says that you become a citizen of a state if you reside there. You know, you establish a residence there, not temporary, but you're a resident there. And there's every reason to believe that if residence is necessary for state citizenship, it was also assumed to be relevant to U.S. citizenship in the very same clause. The word reside is right in the clause we're talking about.
And you point out something else that's important, too. I mean, Trump made reference to legislation, and the Civil Rights Act of 1866 is part of that legislative record that needs to be examined. And the phrase in the Civil Rights Act of 1866 that was tightened up for the provision in the 14th Amendment we've been describing, but it's telling because it gives you an mind's eye in terms of what legislators were thinking.
Yeah, and that phrase says that all persons born in the United States are not subject to any foreign power. That was what the original phrase of the Civil Rights Act of 1866 said, and the 14th Amendment was enacted to constitutionalize the Civil Rights Act of 1866 because Republicans, first of all, because Andrew Johnson had vetoed that act, saying it was unconstitutional, went beyond Congress's powers under the 13th Amendment, and secondly, Republicans were worried that Democrats are going to be readmitted to Congress and they would repeal the Civil Rights Act of 1866, which they promised to do. So they wanted to pass a constitutional amendment so they couldn't repeal the act. They weren't trying to change the act. They were trying to constitutionalize the act. Now, why did they change? And then after they enacted the 14th Amendment, they repassed the Civil Rights Act to ensure that it was constitutional. And they used the original language, not subject to any foreign power, when they reenacted the act after they put the 14th Amendment into effect. So why did they change the language to subject to jurisdiction thereof? And this is debated, and I'm not saying there's a clear 100% answer as to why they changed the language, but the explanation that makes the most sense to me is that they changed the language to ensure that Indians were included in the category of persons not within the jurisdiction of the United States, because it would be a little unclear or ambiguous whether Indians were subject to a foreign power. Native American tribes were not a foreign power in the sense that other countries are. They were subsumed within the United States. So subject to the jurisdiction was broadened out, so it would include them. And then by broadening it out, it would also include other categories of people who were excluded from birthright citizenship because they were not subject to the jurisdiction, along with Indians and diplomats and et cetera.
Is there any possibility that the Supreme Court could cop out and punt this and say, look, we're not going to decide the merits of what subject to the jurisdiction thereof means because this cannot be done by executive order. This is not the province of the executive. It's the province of Congress. And so this requires congressional action.
No, but what is the province of Congress is their naturalization power. Congress has the power. The president does not have the power. Congress has the power to naturalize people, which is what happened to Native Americans. There was a law passed that gave them citizenship by statute. That's the naturalization power. But the president's oath is to the Constitution. The president has as much right to interpret and apply the Constitution as any other constitutional officer does, subject, of course, to judicial review, which is what we're now going through. So the courts do get a word in as to whether the president has acted consistently with the original meaning of the Constitution. But before it ever gets to the court, the president has the opportunity to express his opinion on that by means of his executive order.
Speaking of executive orders, wanted to get your view on another topic. Yesterday, President Trump issued an executive order to crack down on mass mail-in voting. The order requires Homeland Security to create a list of U.S. citizens with the help of Social Security Administration, requires that the Postal Service only sends mail-in ballots to approved voters, and requires a unique barcode tracking the ballots in secure envelopes. You can be sure that this will be litigated. And this is obviously President Trump trying to do by executive order what he can't get John Thune to get done. So what do you say to the constitutionality of that executive order?
Well, Dan, I'm going to be quite frank with you. The cruise ship that I'm on the Flower Power 60s rock band cruise, and our cruise ship is just pulling into Aruba, and I'm seeing us pull up to dock here. And believe it or not, while I've been listening to rock and roll for the last 4 or 5 days, while I've been editing my Wall Street Journal piece, I was unfamiliar with this thing you've just told me about.
Oh my gosh!
Order, which sounds very interesting to me, and it sounds like I'm going to have to now go to work on a new op-ed.
Well, enjoy
executive order.
Enjoy your whale watching or kayaking or whatever goes on with you hippies.
This is just rock.
Oh.
I don't even leave the ship when we're in port. I just listen to the music. It's a 1-week floating music festival, and it's like one of my best weeks of my year.
Okay, all right. Well, I'm sorry. Thank you for joining us. I didn't mean to interrupt you when you're communing with your previous self there.
Last night was the Beach Boys, and we had Blood, Sweat, and Tears, and the lead singer from Chicago, and
Peter Cetera.
There's been one. What's that? Yeah, no, he's the new current lead singer of Chicago. The one that took over from him in 1985.
Yeah.
So he's been at it for quite a while.
I stopped listening to Chicago in 1985. Yeah.
Yeah, me too. But but they played the good stuff. Believe me, they played the good stuff, the original good stuff. So
all right,
25 or 64. All right.
Constitutional lawyer, rock and roller. Yeah, right.
I was a rock and roller. I was in a band called the Royal Knights. We played at the Del Prado Hotel in Hyde Park when I was in college. In my book, Our Life for Liberty, there's a picture of me. I look just like Buddy Holly. And if I had only known who Buddy Holly was and how cool he was, I wouldn't have been embarrassed by my horn-rimmed glasses back in those days. And
this was what type of music?
Rock and roll. We were the Royal Knights, and we were out of Calumet City. I played rhythm guitar, which means I couldn't play guitar all that well. But we were the lead guitar player. They're the ones that know how to play the guitar. But I'm just kidding. At any rate, it was a fantastic, experience being a rock and roller for several years, and I think I'm still living the dream.
And this is now we got a couple of texts that people are interested. What is the name of this cruise now? Flower Power Cruise to Aruba? What is this?
It's Flower Power Cruise. It leaves out of Fort Lauderdale. It goes to different islands. We're only in Aruba because there was a huge storm bearing down on St. Thomas, and they had to reroute us to Aruba. And then all the acts that get on the ship in Caracal that would normally get on the ship in mid-cruise, so they change acts. The acts go off, and then the new acts come on for the rest of the week. They had to all be rerouted through charter planes and everything to get the bands to Caracal, where they could board there. And that's when the Beach Boys came on. They played their show and left. They actually didn't stay on the cruise ship with us. But the Flower Power Cruise is Star Vista is the cruise company. And I'm going to tell you, these guys are unbelievable professionals. They were able to rewrite hundreds and hundreds of musicians and crew members to another port by chartering planes because there was no plane service to Caracal. And managed to keep everything flowing perfectly. It's a fantastic. This is our 9th year of this cruise, and next year is going to be the 10th anniversary. I'm sorry that we spent so much time on Birthright Citizenship. We should have been talking about the particulars of this excursion. If you get over to Anguilla, by the way, you should try and get on Aurora Golf Course, the Aurora International Golf Course. I'm sure you got the juice to get on, even though it's a private club. Dad, I have to say, I've taken up and dropped the game of golf 3 times in my life, and I'm not about to start again.
Yeah,
golf is not for me.
I wish I would have dropped it too.
If I want to take a walk, in a beautiful green area, I'll just take a walk, and I don't need to hit the ball to give myself an excuse to take a walk.
Right, and listen to your flower power bands of yore. Yes, perfect.
Yeah.
All right,
yeah,
enjoy your
picture. I was in costume last night, Dan. If you send me an email, I'll send you the picture, but you got to promise not to show it to anybody. And I know this is radio, so you can't show it to anybody on the air, but I'll send you this picture if you want to see it.
Yeah, I do want to see it. All right. Quinn will send you my email address so that so I get that picture, so I have some extortionary material on you. Perfect.
Okay. I'm changing my mind
No,
now.
I'm kidding, of course. Well, enjoy the rest of your trip, and I do mean that as a double entendre, too. It's the 60s. Randy Barnett.
Let me
ahead.
plug one more book. Buy a Life for Liberty, The Making of American Originalists. You'll see the picture. I have all the pictures of me as a rock and roller in the Royal Knights out of Calumet City. If you buy that book in color, these are color photo insert. You can see the pictures of me. Buy that book on Amazon. A Life for Liberty.
Cal City's favorite son, a man of many talents, Randy Barnett, Georgetown law professor. The latest book we talked about last week, we'll mention again, Felony Review, Tales of True Crime and Corruption in Chicago. Randy Barnett, thanks so much, as always. Appreciate it.
Thanks. Yeah, it's always fun with you, Dan. Appreciate it. Bye.
Thank you. And he joins us on Chicago's Morning Answer.
The stories you need to know to start your day. This is Chicago's Morning Answer on AM 560. The Answer.
Your family and friends love you, but they hate seeing you in pain all the time, especially heading into vacation season. Allow me to recommend my friends at QC Kinetics. They will take care of your pain and let you go right on with your day. It's that easy. Listen, if you answer yes to more than one of these questions, then you're a great candidate. Do you have consistent joint pain in your knees, hips, shoulders, or back? Does pain rob you from a good night's sleep? Are you missing work or saying no to